If your loved one created a will, then you might need to apply for probate. Who applies? Generally, the executor nominated in the will applies for probate. Now, it's important to remember that sometimes the executors mentioned in the will are not able to apply for probate. For example, they might have passed away already, or they may be in bad health, or they simply may not want to do it. Just because an executor is nominated in the will doesn't mean they're forced to act as executor. Every executor has the right to say no. An executor can step down by signing a simple document called a renunciation. Sometimes wills nominate a backup executor, just in case the first mentioned executor cannot act or is unable to act. The backup executor can also apply for probate if the primary executor is unable to do so. So as long as you're mentioned as an executor in the will, whether a primary executor or a backup executor, you have the right, generally speaking, to apply for probate. Our legal team is able to have a free discussion with you to let you know who the right person is to apply for probate. Sometimes we see situations where none of the executors appointed in the will are able or willing to apply for probate. If that occurs, the will is still valid, and generally what happens is one of the beneficiaries in the will is able to apply for probate instead of the executors nominated in the will. That process has a special name. It's called Letters of Administration with Will Annexed. Sometimes 2 people or 3 people may be nominated as joint executors, and it's perfectly normal for one or some of them to say, hey, I don't want to apply, and step down, and only one person carries on the task. That's also okay. If your loved one died without a will, then you might need something called Letters of Administration. Click on the link below to find out more information about this topic. The process for probate is pretty straightforward. The executors need to sign some court documents. The court documents and the will are lodged with the Supreme Court. The Supreme Court then reviews the will, reviews all the court documents, and makes sure everything is in order. If the court is happy with everything, then they issue a grant of probate. This is posted directly to the executors who applied. Once the grant of probate is issued, then the executors are able to access the assets of the estate, information of the estate, and do anything that the deceased person could have done if they were alive. Once probate is granted to the executors, then the executors can get on with the job of finalising the deceased estate. Sometimes you don't need to apply for probate. You generally need to apply for probate in these specific circumstances. If your loved one had real estate in their sole name, or owned real estate as tenants in common with someone. If an organisation, such as a bank, the Australian Taxation Office, a super fund, tells you that you need probate for you to access the assets. If your loved one had money in a sole bank account over a certain amount. This amount varies from bank to bank, but it's usually over $20,000 or $50,000. If your loved one had shares or investments in their sole name over a certain amount, usually $20,000. If you're unsure whether you need to apply for probate, give us a call and we're happy to have a free discussion with you to let you know whether you actually need probate. Once the court documents are lodged with the Supreme Court, it generally takes 3 to 6 weeks for the court to review the documents. If everything is approved, then the grant of probate is sent out to the executor. But sometimes the court may have questions. This is called a requisition. If you're using the Estates Plus service, we will help you deal with any questions the court may have. Using us to help you get probate is often a lot easier than trying to do it yourself. We do this day in, day out. We have lots of experience with probate applications, so we can help you get it right the first time. Our legal team is able to provide you as much help as you need. We can take care of everything for you if that is what you require. We're able to take care of the whole process for you from start to finish. We can take care of the probate application for you. We can also guide you and do all the work that needs to be done after probate is granted. For example, issuing certain government notices, preparing other documents for the beneficiaries to sign, dealing with other estate issues that need to be done after the probate is granted. To get started with the process, all you need is a copy of the death certificate and a copy of the will. You generally need the original will to apply for probate. But if you don't have the original will and you only have a copy, then you can still apply for probate. But you need to provide the court with a little bit more information about why the original cannot be obtained. To apply for probate, we also need some basic information about the assets and liabilities of the estate. Don't worry, we don't need any valuations or anything like that. A reasonable estimate as to the asset's value is good enough. And if you don't know the value of a certain asset, don't worry, you can still apply. Getting a grant of probate gives you the power to access the assets of the estate. It allows you to get hold of those assets so you can distribute it to the beneficiaries mentioned in the will. Probate also gives you the power to access information about the estate. This might be relevant to you if you need to access information about unclaimed super or taxation information. Our legal team will prepare all the probate documents so they're ready to be filed. You don't have to complete anything. There are no templates for you to fill out. Everything is ready to go and just needs to be signed. To sign the court documents, you just need to visit your local Justice of the Peace. We have lots of experience dealing with probate matters, so you can rest assured that you're getting great quality legal service. We make sure our prices are cheaper than other law firms because we do probate day in, day out. If you have any questions about the process of applying for probate, get in touch with us for a free discussion. Remember, any money that you spend on our services is reimbursable by the estate, so you can claim a reimbursement later on when the estate money becomes available. Thanks for watching, and remember, if you have any questions about anything at all regarding probate, get in touch with us for a free discussion.